and welcome to today's Tuesday Tip. Navigate, starting in June, will do a series of workshops on residents' rights and responsibilities, hopefully to help residents and management resolve some of the issues that we have on property. Navigate gets hundreds. See how thick this is? Hundreds of resident complaints. And so in an attempt as a contract administrator to help you all, we want to come out and do workshops in different states. Of course, we will be doing Alabama, Mississippi, Connecticut, and Virginia. But if you have a state that we're not the contract administrator of, but you would like one of the workshop series conducted in your state, please just give us a call. As you know, HUD has a new Residents' Rights and Responsibilities brochure. The old brochure was a blue ink, kind of denim ink looking brochure, but the new brochure has a pretty burgundy print to it. If you're not giving out this brochure and you still have the old one, you need to discard the old one and start to give out and pass out and distribute the new one. With that being said, the contract administrator's job is to mitigate between the resident and the management company to resolve any issues before it gets out of hand. Sometimes they do get out of hand. Sometimes the residents don't call us, they'll immediately call HUD. If they call HUD, HUD's going to tell them to call the contract administrator first. Sometimes they will call legal services or legal aid. If they have obtained an attorney, there's no negotiating we can do on behalf of management or the resident. I want to just say that the brochure, you all have the resident sign that they have received a copy of the brochure. But it's signed at move-in, usually when they sign the lease. They have so many papers, so many documents. They're so nervous, they're so excited about move-in day and signing their lease and getting their apartment that they fail to actually read this brochure. So that's our attempt for the month of June, is to go over the residents' rights and responsibilities and management's rights and responsibilities. Today I have with me Attorney Hilaire Armstrong. She's a staff attorney for Legal Services of Alabama. Attorney Armstrong, tell us a little, if you would, about legal services and what they do as it relates to housing.
So Legal Services is a nonprofit law firm. We are held throughout the state. We have various locations, but Legal Services Alabama actually helps with housing. Housing can cover various areas from mortgage foreclosures to mortgage modifications to unlawful detainers, better known as evictions, as well as loss of public housing, trying to get your Section 8 voucher reestablished, and just general issues that you may be having with your landlord or the management company. We can try to bridge that gap and or negotiate terms, also explaining lease terms that you may not understand before an eviction takes place.
Very good. Now tell us about some of the calls that you might have received or some of the issues that the residents who contact your company or your service have. What are some of the issues they might have?
One of the main issues that the residents have when they come to Legal Services Alabama is typically problems with repairs. So the first thing I would advise a client to do is to read your lease. See what the lease says, what your rights and responsibilities are in regards to the repairs, whether it's your responsibility to repair or it's your landlord's responsibility. So first I would go to the lease. And then after that, I would look at what type of issue it is. Is it something that's easily solved, or is it a habitability issue, such as no hot water, no AC, no heat? Those are major issues when it comes to housing versus, I need my screen door repaired. So it really depends on what kind of repair needs to be made and whether they've made an actual written request for the repair to be made. A lot of people will just tell a maintenance man or, talk in person, but they don't have a written documentation. And it's very important that residents know that anytime they make any kind of complaint or request, it needs to be in writing. Otherwise, it won't hold up in a court of law. So it has to be written down saying, I, tenant, have a problem with this issue and I'm requesting that it be repaired.
Okay.
So,
as managers, you know, a part of what you do or part of what we do when we come out to do the MOR is that we ask you about your work order process. And you're correct. Each management company, even the local housing authorities, should have some type of work order process that they do. The resident should be able to write down the work order or call in the work order and management write it down. In cases of emergencies, they should be given some type of information to tell them what to do if the office is closed and a maintenance issue comes up. In our world, Attorney Armstrong, we always say document, document, document.
Right.
So that's part of the things that we want to go, I call it on the road, and do in our workshops. We want the residents to understand the importance of communication with management and vice versa. We want management to understand the importance of communication with the resident. In the cases that you're talking about or that you're speaking of, if a resident has a maintenance issue, there should be some type of guideline either in the house rules or the tenant selection plan or something that tells the resident how to go about making that request for maintenance.
that's correct. And most of the time, I'll ask, have you actually reported it to your landlord? Before an attorney would step in, we would make sure that, like you said, there's an open line of communication. Because if you haven't told the management company and or landlord that you need this repair, legally there's nothing we can do because the landlord or the management company has not told you that they're not going to make the repair. They just don't know. So we do encourage them to speak with their management company or their landlord and to follow the right process or procedures to report the issue and give them some time to actually correct it.
Okay, thank you. What are some of the other issues you might have?
A lot of the other issues that we have can really, it goes to the second part of the repairs, when the landlord or the management company does not make the repair.
Okay.
Typically, this is more so for private landlords, not necessarily a HUD type property, because they kind of have a little more guidelines in terms of reporting to different people to get problems fixed. Mm-hmm. But typically, if you're in a private landlord situation and the landlord is just ultimately refusing to make vital repairs, these are repairs that would be a material default of their rights. Okay. In the lease. Most of the time, after you've made request after request and the landlord's either avoiding you and or just refusing to make the repairs, and if it's a habitability issue, the only way by law that you can get a landlord to make a repair would be to send them the standard 14-day letter.
Okay.
So the 14-day letter is where you write your landlord a written notification saying that these are all the issues that I need repaired because these are material breaches in the lease. They would have to list those out and say in the letter, citing the code section, saying, if these aren't repaired within 14 days, I'm going to exercise my right to break the lease and move. The tricky thing about the 14-day letter is people want to send these letters but don't want to actually move if the landlord does not make the repairs. Or
So
if the
like
landlord does, yes. So if you send a 14-day letter, you do actually have to move on that 15th day. You can't stay. But in the 14 days, if the landlord has made the repairs and is working with you to get them done, then you also can't move. So that is the ultimate, like, if they're just refusing and this is affecting your ability to live in the household where it's now unsafe for your health or safety, that's when you would go to the 14-day letter. Not for minor repairs. You would just need to work with the landlord or the management company to get those done.
Okay. Since we're talking about maintenance, the season is coming up on us. This has been an unusual season. It's been colder, longer than we had anticipated or we've seen in a while. So with that being said, it's time for maintenance to work on those preventive maintenance things. And that came across me as you were talking. It's time for you to start servicing your air conditioners, because a lot of times in the summer times we have a lot of those calls that the air conditioner is not cooling and it's hot and those type of things. So to the managers out there who have preventive maintenance schedules, go ahead and put those schedules into effect, because it's time to change over from heat to air, even though we have those still chilly, cool days and you flip the heat in the morning time. But we do want to be prepared. Along those lines, we hopefully this month will have someone to come out and talk to us about the heating and the air conditioning and the preventive maintenance. So stay tuned for that. I have received a call, and you let me know if you get these type of issues,
Okay.
where a resident was asked to vacate the property. She was given notice because there was a fight that broke out on the property, and she seems to be in the middle of it. In the HUD project-based lease, before we went to air, guys, we were talking about the different leases. We were talking about the public lease, or the lease for private owners for conventional properties. We were talking about the housing authority, the public housing authority lease, and how they write their own lease. And we were talking about the project-based Section 8 lease that is supplied by HUD and mandated by HUD. And in our conversation, we mentioned the fact that all of the leases are different, so it's important to you to know your landlord law in the state where you live. But in this particular example, the resident was given a 30-day notice to vacate, to be evicted on the property. And I'm just going to read here what she says.
Okay.
She says, someone on the property beat her up and knocked her teeth out, and she is getting evicted. This is not fair. Well, when we followed up on this resident complaint, it appears that she did call an attorney, but the attorney told her to call us first. And I guess he wanted her, as you say, to report it to the landlord and to HUD.
Right.
And as I say, if you call HUD with resident complaints, they usually tell you to call the contract administrator first. So do you have cases where, I guess, residents or tenants call you because they feel like they're being evicted or given those lease violations for no reason at all?
Yes, I actually had a client a couple weeks ago come in, and she said that a neighbor had said that she was in the parking lot brandishing a gun, and that was her violation. And the client disclosed to me that yes, she did have a gun with a permit, but it stays in her home. She doesn't carry it anywhere else. And so as I, told her she wasn't being evicted, but she got this lease violation based off of what somebody else said that they saw or observed. And I told her, I said, first you need to contact the management company or the landlord and let them know, hey, that's not what happened. You always need to let them know your side of the story, because most management companies try to do a little bit of investigation before they send out some kind of lease violation. And if they don't, then this is your notice that you need to let them know that there's a different side of the story. So I would always say start with the management company and let them know what's going on your side of the story, because a lease violation for us doesn't become a legal issue until you're getting evicted.
Okay.
So for us, it's just, well, this is just a warning. Don't do that anymore. Try to stay on your P's and Q's. Talk with your management company and see what ways you can avoid getting any kind of violations depending on what type it is.
Okay. With that being said, we're going to end our segment today, and we're going to...
I had a comment.
Oh, we have a comment. I'm sorry.
Yes, this is from Burnell Calhoun. She says, knowledge is power. This is great. Please tell them they cannot withhold rent due to manager not making timely repairs. Is there any situation when a resident can withhold rent payments?
No. There's never any time where a resident can withhold money for rent. It's specifically stating in the law that you cannot do it. The only option, unfortunately, in Alabama law, you'd have to check your state, as we said before. Alabama does not have any other legal recourse other than sending the typical 14-day letter. If you don't send a 14-day letter and you withhold rent, you will be evicted. And you're not going to have any defense. Your repairs would only come into mitigating your damages after you've been evicted. So if you don't want to be evicted, continue to pay your rent, work with the landlord and the management company to get those repairs done. And if it's hazardous to your health and safety, then resort to the 14-day letter, but that's not your first line of defense. First line would be open communications, speaking with the landlord and management company to try to get those repairs done.
Would you suggest that they take pictures of anything that's wrong or?
Yes. One thing I was gonna get into that I didn't really get into, before you move in, take pictures of how the place was when you got there. Also, when damages come, document those with pictures. You can take them on your phone, a camera, what have you, just to have proof, so that if you do get into a legal issue, you do have some documentation and you don't say, well, I never took pictures at the time. Also, it's important for the landlord to know what level of damage that there is. So that'll also help them when they're trying to figure out what the solution is to the repair, if they've seen the damages through pictures or have come out to the apartment to see what the damage is or what repairs needed. So yes, document, written notes for everything, pictures for everything, any kind of documentation you can create them. It'll help you in the future.
Great. And we use, with project-based, we use what's called a move-in inspection form.
Okay.
And on the move-in inspection form, sometimes we will see a lot of blank space.
Mm-hmm.
No checks, no anything, signed by management and signed by the resident. And we usually give a finding for this because HUD says that we need to know the condition of the unit as you move in. So if you're one of those guys that leave all of the space blank, make sure that you have okay, check. You can do the okay and the little parenthesis signs up under it to continue, but have something on that form besides a blank form. Ebony, do we have any more questions before we close out?
No, I think that's it.
Okay, I wanted to remind you, and thank you so much for coming,
It's my
Attorney
pleasure.
Armstrong, that we are going to be doing this series on residents' rights and responsibilities. We're doing it so that the residents, as I said, will know their rights, and so that the communication between management and residents can improve. And with that being said, hopefully we'll have someone from Legal Services on the workshop or in the workshop with us, and we can get a better understanding of the laws in the state where you live and of the intentions of management and the intentions and interpretation of residents. Until then, we'll see you at our next Tuesday tip. Thank Attorney Armstrong again, and have a great day. We'll see you next Tuesday.